pastures seem pretty lush. Huge fan. Australia.
I asked them if they'd been having, but they said fog city. Cool. Companies to share money. I'll send different issue. I'm just talking about the scheme of the world. Actually, nice environment.
And then you'll go straight. Yeah. I don't want that. You just relied on paying attention. Council.
Oh, thank you.
Call the matter for judgment.
Rodriguez and Sons Proprietary Limited, Queensland Bulk Water Supply.
These representative proceedings arise out of the large-scale flooding that occurred in the greater Brisbane and Ipswich area from on around 11 January 2011. Before I summarise the nature of the proceedings and the findings made in the balance of the judgment, three matters should be noted. First, the obvious question that arises is why these proceedings were heard in the Supreme Court of New South Wales when every relevant fact, matter and circumstance occurred in Queensland. Although it is surmise on my part, the answer appears to be that at the time these proceedings were commenced, there were no legislative provisions in force governing representative actions in the Supreme Court of Queensland. Such provisions are now operative. Thus, the hearing of this case in this state appears to be an accident of time. For the sake of completeness, I note that this court's jurisdiction to hear the matter derives, at least in part, from Section 4.1 of the Jurisdiction of Courts Cross-Vesting Act of Queensland. Second, on the afternoon and evening of 10 January 2011, severe flash flooding occurred in Toowoomba and the Lockyer Valley, including the towns of Helidon and Grantham. Tragically, a number of people lost their lives. That flooding is not the subject matter of this case. There is no relevant connection between the conduct of any of the defendants and the occurrence of that flooding. Instead, the large increase in flows in Lockyer Creek that occurred on that day is simply part of the factual background to the over-the-floor flooding that was occasioned at other places in the Brisbane River catchment on 11 and 12 January 2011 and beyond. Third, during 2011 and 2012, a Commission of Inquiry constituted under the Commissions of Inquiry Act of Queensland was conducted into various matters concerning the flooding the subject of these proceedings. Parts of the evidence before that inquiry were tendered in these proceedings, as were some of its recommendations. However, the bulk of the evidence before the Commission of Inquiry and its report were not tendered and therefore could not be considered by this court. I have not read the Commission of Inquiry report. Background. Like the situation at present, from 2001 to 2008, severe drought was experienced in eastern Australia, including southeast Queensland. By 2009, the drought had broken. Towards the end of calendar year 2010, significant rainfall was expected and fell in southeast Queensland as the effect of a La Nina climate phase took hold. The rainfall caused the declaration of a number of so-called flood events and the conduct of flood operations at Wivenhoe Dam and Somerset Dam in the last 3 months of 2010. By early January 2011, the catchment area of the Brisbane River was saturated. Despite significant flood releases having been made during December 2010, as at early January 2011, each dam was above its so-called full supply level. Although the period from 2 January 2011 was referred to as the January 2011 flood event, releases for flood mitigation from Wivenhoe Dam and Somerset Dam ceased on that day. They would not resume again until the afternoon of 7 January 2011. From 3 January 2011, various weather forecasts began to predict significant rainfall over the Brisbane River Basin, including the catchments above the dams. These forecasts steadily increased and became ominous over the following days. Significant amounts of rain fell in the Brisbane River Basin, including in the catchments above the dams on 5 January 2011. It continued for the next 2 days, although it eased on Saturday, 8 January 2011. On Sunday, 9 January 2011, the heavens opened. Over that day and the following 2 days, rainfall totals approximating 350 to 400 millimetres in depth were experienced in the catchment areas above the dams. The rainfall on 11 January 2011 in the area of Wivenhoe Dam was of biblical proportions. Extreme rainfall was also experienced during this period in the catchments downstream of the dams, especially in the Lockyer Valley, which caused a significant increase in the flow of water in Lockyer Creek. Lockyer Creek flows into the Brisbane River just downstream of Wivenhoe Dam. Extreme rain also fell in the catchment area for the Bremer River. The Bremer River flows through Ipswich and into the Brisbane River at a point 16 hours flow time downstream of Wivenhoe Dam and just above Moggill, a suburb of Brisbane. The central business district of Brisbane is a further 10 hours flow time downstream of Moggill. During 11 January 2011, the rate of inflow of water into Wivenhoe Dam increased rapidly, so much so that by 10 a.m. the rate was above 10,000 cubic metres per second. The level of Wivenhoe Dam rose above elevation level 74 metres Australian height datum. That level is recognised by the Manual of Operational Procedures for Flood Mitigation at Wivenhoe Dam and Somerset Dam as a point at which a consideration of Wivenhoe Dam safety predominates. From around 8 a.m. on 11 January 2011, the flood engineers responsible for flood operations at both dams directed that there be further openings of the radial gates at Wivenhoe Dam in an attempt to address the rising reservoir levels. This continued until 7 p.m. that evening, by which time the reservoir level had stabilised at a height of elevation level 74.97 metres. Thereafter, it began to slowly drop. The peak rate of outflows from the dam was 7,464 cubic metres per second. The manual designated a flow rate of 4,000 cubic metres per second in the Brisbane River at Moggle as the threshold point at which homes and businesses downstream of the dams would commence to be flooded. The flows in the Brisbane River at Moggle comprise the outflows from Wivenhoe Dam, as well as outflows from Lockyer Creek and the Bremer River into the Brisbane River. Unfortunately, to a significant extent, the large increase in outflows from Wivenhoe Dam coincided with large outflows from Lockyer Creek and the Bremer River. The peak flow rate experienced at Moggle was at around 1 p.m. to 2 p.m. on 12 January 2011. It was between 10,420 cubic metres per second and 10,700 cubic metres per second, of which between 4,200 cubic metres per second and 5,300 cubic metres per second was attributable to releases from Wivenhoe Dam. The flooding of homes and businesses in areas proximate to the Brisbane River, the lower Bremer River and the lower part of Lockyer Creek commenced on 11 January 2011 and continued through at least the following day. The distress, dislocation and heartache that was occasioned by the flooding was taken as a given in the proceedings. The parties. The plaintiff, Rodriguez and Sons Proprietary Limited, was one of the many affected by the flooding. As at January 2011, it conducted a retail sporting goods and clothing store under the name Sports Power Fairfield from within the Fairfield Gardens Shopping Centre in Fairfield. Fairfield is approximately 5 kilometres southeast of the central business district of Brisbane. Vincente Rodriguez was the sole director of the plaintiff. At around midday on 11 January 2011, he was contacted by his wife Maria and told that the management of the shopping centre had advised that all the retail outlets had to be closed by 12 p.m. due to the risk of flooding. He rushed to the store and assisted his wife to stack expensive items of stock on elevated tables. They then left to secure their home before returning the next morning at 6 a.m. with other members of the family to remove and store stock. They were forced to leave at around 11:30 a.m. as floodwaters were approaching the entrance to the shopping centre. Mr. Rodriguez and his family were not able to return to the store until 16 January 2011. When they did so, they discovered the flooding had, in Mr. Rodriguez's words, devastated the shop. The extent of the inundation and the nature of the damage they suffered are addressed later in the judgment. As fate would have it, the Rodriguez family home in Graceville was also devastated by flooding. Whether any of the defendants are legally responsible for the damage occasioned there was not litigated during this phase of the proceedings. In these proceedings, the plaintiff seeks to recover for the loss and damage occasioned by the inundation of its store. This includes the loss of stock, clean-up costs, and lost profits for the period in which it could not trade and for a period thereafter. As noted, these are representative proceedings under Part 10 of the Civil Procedure Act of New South Wales. The plaintiff brings the proceedings on its own behalf and on behalf of a group of persons who satisfy the group definition and have not opted out of the proceedings. The group definition has two limbs, both of which must be satisfied. To satisfy the first limb, the group member must have suffered one or both of two subcategories of damage. The first subcategory concerns persons that held an interest in land and either suffered loss or damage from the inundation of that land by floodwater from the Brisbane River or Bremer River or their tributaries in the period from 9 January 2011 to 24 January 2011, or had their use or enjoyment of that land interfered with by reason of that inundation, such as they suffered loss or damage. The other subcategory is persons who own personal property in that period which was damaged or destroyed by the inundation of land on which it was located by floodwater from the Brisbane River or Bremer River or their tributaries during the same period. The second limb of the group definition is that either the group member or an insurer who has indemnified them for loss arising out of the subject matter of the proceedings must have entered into a litigation funding agreement with IMF Bentham Limited. There are approximately 6,870 persons or entities who are group members. They are named in the schedule to a statement of claim filed in a parallel set of proceedings commenced by one of the group members, Ms. Lynette Lynch. Those proceedings were commenced to address a potential issue that arose concerning the application of the Limitation of Actions Act of Queensland to representative proceedings filed in this court. The Lynch proceedings were stayed pending the outcome of these proceedings on terms the parties to those proceedings will be bound by the findings in these proceedings. There are three defendants to these proceedings, namely Queensland Bulk Water Supply Authority, trading as Seqwater, Sunwater Limited, and the State of Queensland. Seqwater was established by Section 6 of the South East Queensland Water Restructuring Act 2007. Seqwater was vested by statute with ownership of Wivenhoe and Somerset dams and the land on which they are located. Seqwater received statutory permissions enabling it to interfere with the flow of water in the Brisbane River for the purpose of operating the dams for flood mitigation and water supply. There was a dispute about whether it was conferred with a statutory function of flood mitigation. Seqwater was the employer of two of the four flood engineers who were either on duty or conducting flood operations during the January 2011 flood event, namely Mr Terry Malone and Mr John Tibaldi. At all relevant times, Sunwater was a government-owned corporation with the meaning of Section 5 of the Government-Owned Corporations Act of Queensland. It is a public company registered under the Corporations Act of the Commonwealth. As of January 2011, Sunwater was contracted to provide flood management services to Seqwater. Sunwater was the employer of one of the four flood engineers, Mr Robert Eyre. The Eyre was the senior flood operations engineer. The state is sued as the employer of the fourth flood engineer, Mr John Ruffini. Each of Messrs Malone, Tibaldi and Eyre gave evidence in the proceedings. Mr Ruffini did not. Plaintiff's case overview. The following is just a brief précis of the principal contentions made by the plaintiff and the defendants. The plaintiff sues each of the defendants in negligence, nuisance and trespass. The plaintiff pleaded that each of Seqwater, Sunwater and the flood engineers owed a class of persons, including itself and the other group members, a duty to take reasonable care in the conduct of flood operations at both dams to avoid the type of harm referred to in the group definition. In the case of Seqwater and Sunwater, the plaintiff contended the duty of care they owed was a non-delegable duty, that is, a duty to ensure reasonable care was taken in the conduct of flood operations, specifically by the flood engineers. Otherwise, the plaintiff contended that each of Seqwater, Sunwater and the state are vicariously liable for any breaches of any duty of care owed by the flood engineers to the plaintiff and group members. At the heart of the plaintiff's case is the contention that during the period from 2 January to 10 January 2011, the flood engineers were obliged but failed to evacuate water from the dams in advance of rainfall predicted by rainfall forecasts. Critical to this allegation is the contention that the content of any duty of care owed by the flood engineers in relation to flood operations was governed by the manual. The plaintiff contended that irrespective of the approach at other dams, the manual unambiguously required the use of forecasts in conducting flood operations, especially the selection of flood strategies by reference to predictions about reservoir levels based on rainfall forecasts, and the making of releases from the dams determined at least in part by reference to forecast rainfall. The plaintiff also contended that the manual embodied an overall risk management approach to flood operations. This was said to require that releases from the dams be made with a view to minimising the risk of urban damage as well as dam failure at the expense of the disruption to local communities caused by the inundation of bridges that span the upper part of the Brisbane River below Wivenhoe Dam, as well as to the risk to the water supply if the full supply level of water was not retained in the dams following the completion of flood operations. The plaintiff contended that the flood engineers comprehensively failed to apply the manual throughout the flood event. The plaintiff contended that they were obliged but failed to continue flood operations from 2 January 2011. The plaintiff contended the flood engineers waited too long before resuming releases from Wivenhoe Dam on the afternoon of 7 January 2011 and thereafter made releases at too low a rate until well into 10 January 2011 when storage space in Wivenhoe Dam below elevation level 74 metres was almost exhausted. The plaintiff contended the loss of storage space in the dams for the flood engineers' conduct of flood operations culminated in releases having to be made at Wivenhoe Dam from above elevation level 74 metres on 11 and 12 January 2011 to address dam safety concerns. The plaintiff contended that contrary to the manual, to the extent that the flood engineers applied any flood strategy in the manual, they did so by selecting a strategy based on the actual level of water in Wivenhoe Dam and not the level predicted by the use of rainfall forecasts. Although the plaintiff made many complaints about the flood engineers' approach to releases, 3 related complaints predominated. The first was that in determining the amount of water to release, the flood engineers only based their releases on an estimate of inflows determined by rain that had already fallen, so-called rain on the ground, and thus effectively ignored rain that was forecast. The second was that the flood engineers wrongly prioritised avoiding the inundation of the bridges just referred to at the expense of avoiding or minimising the risk of urban inundation. The third was that while not considering any estimate of inflows based on forecasts in deciding to make releases, the flood engineers simultaneously modelled making releases for many days into the future, which necessarily assumed that rain would not fall in significant amounts downstreams of the dams and thus permit the releases to be made. Although there was a great deal of expert evidence, 2 expert witnesses were of particular significance to the plaintiff's case. The first such expert was Dr. Ronald Kristensen, a civil engineer from Utah with expertise in hydrology. In his reports and oral evidence, Dr. Kristensen construed the manual, critiqued the conduct of the flood engineers, and set out 10 different scenarios representing simulated alternative flood operations at Wivenhoe and Somerset dams. The position of a flood engineer is in one sense sui generis, and it can be performed by persons with different forms of qualifications, specifically in engineering, hydrology and meteorology. Whether Dr. Kristensen was suitably qualified to undertake such a role and comment on the conduct of others performing such a role was one of the issues in the proceedings. The plaintiff relied on Dr. Kristensen's evidence and simulations, both as material informing its analysis of the allegations of breach of duty levelled at the flood engineers and as the basis for its case on causation. The plaintiff put forward Dr. Kristensen's simulations as embodying the counterfactual flood operations that it says a reasonably competent flood engineer would have undertaken during the January 2011 flood event, but for the flood engineer's breaches of duty. The differences between the 10 simulations put forward by Dr. Kristensen reflected different starting dates for the counterfactual flood operations and different governing assumptions, which in turn reflected different aspects of reasonably competent flood operations that the plaintiff contended should have been adopted. 2 governing assumptions are of particular relevance. The first concerns what period of forecast, and thus what forecast product a reasonably competent flood engineer was required to utilise in flood operations. The second is whether a reasonably competent flood engineer would have made releases below the full supply levels for each of the dams during flood operations, and if so, how far below. As an indication of the extent of the dispute over Dr. Kristensen's evidence, he was cross-examined for 22 days during the hearing. Over 370 pages of this judgment are devoted to a consideration of Dr. Kristensen's evidence and simulations, as well as the defendant's attacks on both. The second expert that was of particular significance to the plaintiff's case was Dr. Mustafa Altanaka. Dr. Altanaka is a highly qualified mathematician. He is the Director and Research Professor at the National Centre for Computational Hydroscience and Engineering at the University of Mississippi. Using his DSS-WISE software, Dr. Altanaka undertook 2-dimensional numerical modelling, simulation and mapping of the January 2011 flood event and its effects across the Brisbane River catchment. He produced a mathematical model which the plaintiff contended could be manipulated by altering the discharge outflows from Wivenhoe Dam to accord with Dr. Kristensen's simulations. The plaintiff contended that Dr. Altanaka's modelling was sufficiently robust to enable findings to be made as to the depth of flooding under Dr. Kristensen's simulations for locations of 10 metres by 10 metre size within the area of the model, and to the extent necessary for the actual flooding that ensued during the January 2011 flood event. Thus, the plaintiff contended that Seqwater, Sunwater and the flood engineers breached the duty of care they owed to it, that the proper discharge of that duty required the adoption of at least one or more of Dr. Kristensen's simulations, and that using Dr. Altanaka's modelling and supplemented by other evidence, including that provided by Mr. Rodriguez, if outflows from Wivenhoe Dam had substantially accorded with the relevant simulation, the plaintiff's store and the shopping centre it formed part of would not have been inundated. The plaintiff then seeks to extend this reasoning to other group members. The defendant's case overview. The defendants took issue with each and every aspect of the plaintiff's case. The defendants contended that the conduct of the flood engineers throughout the January 2011 flood event was consistent with both the manual and accepted professional practice at other dams and amongst other flood engineers. They contended that on its proper construction, the manual did not require the use of forecasts in either the selection of flood strategy or the making of the releases, or at the very least, the flood engineers reasonably believed that to be the case. They contended that rainfall forecasts were far too uncertain to be used for those purposes in flood operations. They contended that at least some of the flood strategies under the manual were dictated by the actual levels of the dam, and that otherwise the only proper course, given the uncertainties in predicting and modelling forecast rainfall, was to model rain on the ground for the purpose of flood operations, including in making releases. They contended that the flood engineers used rainfall forecasts to ascertain a so-called situational awareness of the flood event and in deciding to reduce releases on account of downstream flows. They contended that form of use of rainfall forecasts during the January 2011 flood event was more than sufficient to comply with the manual. The defendants also contended that the flood engineers' approach was supported by a number of experts that were called to give evidence as to the proper conduct of flood operations, including expert flood engineers as well as experts in meteorology and hydrology. To the extent there was any ambiguity in the manual, Seckwater and Sunwater contended that the revision of the previous version of the manual reinforced the reasonableness of the interpretation and approach adopted by the flood engineers. Further, the defendants contended that both the manual and the relevant legislative regime precluded the flood engineers from making releases from below full supply level at either Ivanhoe Dam or Somerset Dam. The defendants were highly critical of Dr. Kristensen's evidence. They variously contended he was unqualified, dishonest, and that he consciously or unconsciously used hindsight to tailor his opinions and simulations. They contended that his methodology was untested and unendorsed by any other expert, that it was affected by errors inconsistent with the manual, and that its various assumptions were either falsified or not made out. Both Seckwater and Sunwater contended that the plaintiff's pleaded case on breach of duty was tied to establishing that the flood engineers failed to act in accordance with one of those simulations, and contended that the plaintiff's submissions did not reflect that. The defendants also contended that Dr. Altanaka's modelling was wholly unreliable for use in the manner contended for by the plaintiff. The various criticisms included that it was poorly calibrated, lacked the necessary verification of historical flooding, and used incorrect or unreliable inflow discharges at two of its boundaries, namely Lockyer Creek and the Upper Bremer River. Seckwater and Sunwater denied that they owed any duty of care, much less a non-delegable duty. All of the defendants denied the flood engineers owed any duty of care. Even if there was a duty owed, it was contended that each of the allegations of breach of duty had to be assessed by reference to Section 36 of the Civil Liability Act of Queensland. That provision concerns proceedings based on an alleged wrongful exercise or failure to exercise a function of a public or other authority, and provides that any act or omission of such an authority does not constitute a wrongful exercise of failure unless the act or omission was so unreasonable that no public or other authority having the functions of the authority in question could properly consider the act or omission to be a reasonable exercise of its functions. It was also contended that to the extent the flood engineers' conduct was being considered, then each of them acted in a way that was widely accepted by peer professional opinion by a significant number of respected practitioners in the field as competent professional practice, such that by operation of Section 22 of the Civil Liability Act of Queensland, the flood engineers could not be found to have breached any duty of care they owed. Both Seckwater and the state denied they were vicariously liable for any breaches of duty by the flood engineers they employed. All the defendants denied there was any unreasonable interference with the use and enjoyment of the plaintiff or any other group member's interest in land sufficient to amount to a nuisance. The hearing and issues for determination. The substantive hearing of this phase of the proceeding commenced with opening addresses on 4 December 2007. They continued until 12 December 2017. They continued until 12 December 2017. A view of the shopping centre in Fairfield and other relevantly affected properties, both dams, the downstream bridges and other relevant locations in the Brisbane River catchment was conducted over 3 days from 12 to 14 February 2018. The hearing resumed the calling of the first witness, Mr Rodriguez, on 19 February 2018. It continued until September 2018. During October and November 2018, over 1,600 pages of written submissions were filed. Further evidence was filed and argument over the reception of that evidence took place on 27 November 2018. Oral submissions commenced on 28 November 2018 and concluded on 12 December 2018. Dr Altanaka gave further oral evidence from 18 to 20 March 2019. Further written submissions were filed after that. The last written submission was received on 10 May 2019. The transcript of the proceedings exceeds 10,000 pages. Over 2,100 pages of written submissions were filed. The text of the witness statements and experts' reports occupies over 50 volumes. The electronic database contains over 26,000 documents, including over 700 spreadsheets. It is appropriate to note that the task of considering this material and preparing this judgment would not have been possible without the tireless professionalism of my associate and Tip Staves. This phase of the hearing was directed to resolving 4 sets of issues that were finally identified by orders made by the Court on 14 September 2018. The first set is all issues of fact and law that arise from the claims brought by the plaintiff in its personal capacity. The second set is all issues of fact and law except for the assessment of damages that arise from the claims of a selected sample of the group members, namely Mr John and Mrs Betty Keller, Ms Lynch, Ms Sharon Visser and Ms Lynette Harrison. The third set of issues is the respective rights and liabilities of the defendants in the event that one or more of them is found to be liable to the plaintiff or one or more of the sample group members. And the fourth set of issues are identified by a series of questions that mostly arise in the plaintiff's case, but which affect all or at least most of group members as well, that is, the common questions. Judgment overview. This part of this chapter summarises the effect of the findings and the balance of the judgment on the principal matters in dispute between the parties. It should not be taken as a substitute for or variation on the discussion and findings in subsequent chapters. The manual. The starting point is the dispute over the meaning of and application of the manual. The relevant version of the manual was approved by the Director General of the Department of Environment and Resource Management under Section 371 of the Water Supply and Safety and Reliability Act of Queensland in December 2009 and gazetted in January 2010. The manual did not have the force of law, save that certain parts of it relating to the gate operating procedures at Wivenhoe Dam and Somerset Dam had effect as conditions of a development consent. Nevertheless, the manual was of legal significance in 3 respects. First, the Water Supply, Safety and Reliability Act of Queensland exempted a dam owner who observed the operational procedures in the manual from civil liability for any act or omission that was honestly made and without negligence. If those conditions were met, any liability that the dam owner would otherwise incur is imposed on the state. Second, in purporting to comply with the manual, Seqwater conferred control over the dams on the flood engineers to commence and conduct flood operations. Third, the requirements of the manual heavily informed the content of any duty of care owed by the flood engineers. One matter all the relevant experts agreed upon was the necessity for flood engineers to follow the manual. A reasonably competent flood engineer could not refuse to apply the approach stated in a flood mitigation manual because they disagreed with it. A vast number of issues were debated about the meaning and requirements of the manual. At this point, it suffices to state that in large part I accept the plaintiff's submissions as to its interpretation. 2 particular matters should be noted. First, any reasonable reader of the manual, including any reasonably competent flood engineer, would have concluded that the manual adopted an overall risk management approach to flood operations that acknowledged the uncertainties in forecasting rainfall and using forecasts to determine dam inflows and downstream flow, but sought to address that uncertainty by requiring the flood engineers to address the flood objectives in their specified order. Thus, the manual required the flood engineers conduct flood operations with the objective of ensuring dam safety and optimising protection against urban flooding ahead of the objectives of avoiding the inundation of rural bridges, and retaining the dams at full supply level at the conclusion of a flood event. Second, any reasonable reader of the manual, including any reasonably competent flood engineer, would have concluded that the manual made rainfall forecasts a central component of the flood engineer's decision-making processes. There are 12 references to rainfall forecasts in the manual. Contrary to a suggestion of one witness, their inclusion in the manual was certainly not a mistake. The manual unambiguously and stubbornly required that, quote, best forecast rainfall, unquote, be used to make predictions for the purpose of determining the anticipated storage levels in the dams in order to select the applicable flood strategy. The manual directed that within those strategies, consideration be given to the flood objectives in their order of priority. In turn, that required that rainfall forecasts be used in the determination of release rates, while still leaving some scope for professional judgment as to what forecast product to use and what those rates should be, a matter I'll return to. As noted, one aspect of the defendant's case was that even if it was considered that their suggested construction of the manual was incorrect, the flood engineers nevertheless acted on a reasonable interpretation of the manual and that it was open to a reasonably competent flood engineer to take the same approach. However, for the reasons explained in the balance of the judgment, even though Messrs Malone, Tabaldi and Eyre sought to explain their understanding of the disputed aspects of the manual, it was to no avail for three reasons. First, I was not persuaded that that was in fact their understanding during the January 2011 flood event. Second, I was not persuaded they gave effect to any such understanding during the January 2011 flood event. Third, in any event, the relevant understanding involved an unreasonable construction of the manual. There was not a single instance where I was persuaded that any of the flood engineers took any impugned action during the January 2011 flood event based on a mistaken but reasonably held belief about the manual's requirements. In relation to their evidence generally, Mr Malone ultimately accepted in cross-examination that he had no recollection of how he interpreted and applied the manual during the January 2011 flood event. Otherwise, I found the evidence of Mr Tabaldi and Mr Eyre to be unreliable. I did not accept their evidence on any contested matter unless it was corroborated by independent evidence, which in most respects it was not. To that end, no support for any aspect of the flood engineer's evidence or approach was to be gained from considering their involvement in the process of revision of the manual during 2009. To the contrary, their deep involvement in its redrafting would have only reinforced to them the very significant changes that took place between the previous version of the manual and the version the subject of these proceedings. The previous version of the manual clearly provided that flood strategies and the range of release rates were determined by observed reservoir levels. The contrast between that version and the manual as enforced during January 2011, with its emphasis on flood objectives, predicted reservoir levels, and repeated references to the use of rainfall forecasts, was dramatic. Two further matters should be noted about the findings concerning the manual. First, as noted, there was a large debate in the evidence about the utility of using forecasts in flood operations, bearing in mind the limitations on their accuracy, the difficulty in modelling dam inflows and downstream effects using predicted rainfall, and the potential consequences of making decisions to release or not release water based on forecasts that proved to be inaccurate or just plain wrong. To a large extent, much of this debate was resolved by the manual. It mandated that forecasts be used while acknowledging the limitations on their accuracy. Second, the findings made about the manual tore a large hole in the case of the three defendants and their attempts to defend the flood engineer's conduct. As noted, one line of defence was that the selection of strategies was dictated by actual and not predicted storage levels, and to the extent that predictions were required, they had to be or could only be formed by reference to rain on the ground modelling and not rainfall forecasts. For some of the defendants, this line of defence wavered. In any event, many aspects of the conduct of flood operations during the January 2011 flood event bore little resemblance to any of the suggested interpretations of the manual. Further, many of the experts called by the defendants accepted the fundamental principle that a reasonably competent flood engineer was obliged to conduct flood operations in accordance with the relevant water control manual. However, when these experts were taken to the words of the manual, they proved unable to explain how their postulated approach was consistent with its clear words. The result was that, to varying degrees, I treated their evidence with greater scepticism than I otherwise would have. Full supply level. It was common ground that both dams were built and operated to provide for water supply and flood mitigation. As noted, one of the issues debated between the parties was whether the flood engineers were legally prohibited from making releases for flood mitigation from below the full supply level for each dam, and if not, in what circumstances could such releases be made. I find that they were not legally prohibited from doing so. In particular, in 2010, Seqwater specifically sought and obtained an approval under Clause 13 of the Moreton Resources Operations Plan, which specifically permitted such releases for the purpose of flood mitigation. Seqwater's attempts to attack the validity of the approval it sought and obtained fails. I also find the manual did not preclude such releases during flood operations after the reservoir level at Wivenhoe Dam first exceeded elevation level 67.25 metres AHD. The defendants adduced evidence which was directed to establishing the existence of a practice at other dams, principally in the United States of America, of not making releases for flood mitigation from that part of a reservoir behind a dam that is designated as the water supply pool. However, that evidence rose no higher than establishing that the regulatory regime in force at those dams prevented such releases. Thus, the only practice that was established was of not releasing water from a supply pool that was inviolable. In light of the findings about the regulatory regime applicable to Wivenhoe and Somerset dams, the establishment of such a practice was irrelevant. Similar findings to those just noted were made in relation to the flood engineers' evidence about their subjective beliefs in relation to making releases below full supply level. Otherwise, the utility of making releases from below full supply level in flood operations, especially when heavy rain forecast, was acknowledged by a number of witnesses. However, in making them, the reasonably competent flood engineer had to pay regard to the manual's fourth objective, namely that there should be no reason why storage should not be retained at full supply level at the conclusion of a flood event. Flood operations during the January 2011 flood event. Each day of the January 2000 flood event and each shift of flood operations during the period from 6 to 12 January 2011 is addressed in detail in chapters 6 and 7. At this point, 8 matters should be noted. First, while the rain that fell in the period from 9 to 11 January 2011 generally exceeded the amount of rain that was forecast, the forecasts and internal assessments that were produced nevertheless pointed to a strong likelihood of very large falls occurring during that period in what was an already saturated catchment. At all relevant times, there was a reasonable possibility of rainfall in, around and below the upstream catchments in amounts higher, sometimes much higher, than the forecasted amounts, and which approximated the amount of rain that actually fell. Second, as noted, from 2 January 2011, flood operations ceased. The duty flood operations engineer, Mr Malone, did not declare another flood event under the manual until 6 January 2011. Throughout that period, both dams were above their full supply level, substantial rain was predicted, and significant rain fell from 5 January 2011. The failure to continue the flood event and the failure to declare a new flood event was completely inconsistent with the manual. Third, although a flood event was declared on the morning of 6 January 2011 and solid rain continued throughout that day with much more rain forecast, releases did not commence until the afternoon of 7 January 2011 after natural downstream flows inundated Burton's Bridge. The failure to commence releases earlier was an instance of the flood engineers subverting the priorities of the manual by seeking to avoid the inconvenience occasioned by bridge closures at the expense of guarding against the risk of urban inundation. Fourth, even after releases commenced on the afternoon of 7 January 2011, and despite the forecast worsening, until midnight on 10 January 2011, the flood engineers maintained their approach of prioritising keeping the remaining bridges open. By that time, the amount of rain that had fallen, the prevailing rainfall forecast, and the reservoir levels pointed to the virtual certainty that flooding of urban areas would occur. Although there was some increase in releases throughout the period from 7 to 9 January 2011 inclusive, they were always held at levels below that necessary to inundate the remaining bridges. Throughout the entire January 2011 flood event, not a single bridge was inundated by a decision of the flood engineers to increase releases. Fifth, to the extent that during the period from 6 to 9 January 2011 inclusive, the flood engineers were operating in accordance with any flood strategy specified for Wivenhoe Dam in the manual, it was strategy W1. That strategy is directed to minimising disruption to rural life and specifically keeping low-lying bridges open. This approach was inconsistent with any interpretation of the manual, including that put forward at various times by the flood engineers and the defendants during the hearing, which was that strategies were determined by observed reservoir levels. That is so because the observed water level of Wivenhoe Dam exceeded the relevant maximum level of strategy W1, namely elevation level 68.5 metres at 8 a.m. on 8 January 2011. However, flood operations continued after that time in a manner that was only consistent with that strategy. If the flood strategies had been selected by reference to a predicted reservoir level that included rainfall forecasts, as the manual required, then irrespective of the period of the forecast product that might have been used, at the very least that would have required the selection of strategy W3 at a much earlier time. Strategy W3 prioritised the protection of urban areas from inundation. 6. On 10 January 2011, an increase in releases from Wivenhoe Dam was delayed because of a concern that combined flows at Moggle above 3,500 cubic metres per second might cause overflow flooding, whereas the manual dictated that the relevant level was 4,000 cubic metres per second. Further, on 9 and 10 January 2011, there was an increase in releases from Somerset Dam that was disproportionate to the relatively low releases from Wivenhoe Dam. This contributed to the rise of Wivenhoe Dam levels. 7th, although the flood engineers asserted that rainfall forecasts were used to acquire a so-called situational awareness and to curtail releases, in substance they ignored them. The flood engineers never determined the applicable flood strategy in the manual based on a predicted reservoir level, much less a predicted reservoir level that utilised a rainfall forecast. They never determined to release water because rainfall was forecast to fall in catchments above the dam, never determined a volume of water to be evacuated based on a raw rainfall forecast, never determined to increase releases because of a concern that forecast rain might fall downstream at a later time and impede releases at that time, and did not undertake any modelling that used forecast rainfall as the basis for flood operations. In substance, the flood engineers' actions were at best only determined by rain on the ground assessments. In particular, the amount of water they determined to evacuate was always based on a rain on the ground assessment, which was directed to a planning horizon of no more than 12 to 15 hours ahead. That period was far too short having regard to both dams' capacity and the catchment flow times above and below the dams. Although they may have remained cognizant of the rainfall forecast, the flood engineers were always effectively assuming that no forecast rain would fall above the dams, while at the same time assuming that forecast rain would or might fall below the dams, but only during the short planning horizon of 12 to 15 hours, with no rain to fall thereafter. This approach underestimated the amount of water that needed to be evacuated and overestimated the capacity of the dams to release water beyond that 12 to 15 hour period. This approach was fundamentally contrary to the manual. It ignored the manual's method of strategy selections, and it meant that within any strategy, decisions on dam releases did not involve a consideration of the flood objectives in their order of priority. 8th, there is no doubt that the conduct of flood operations during the January 2000 flood event was highly stressful and exhausting. In those circumstances, there was always the potential for honest but genuine mistakes to have been made. It follows that considerable caution needs to be and has been exercised against making post-event criticisms with the luxury of time and hindsight. However, the identified failings of the flood engineers do not concern decisions they made in the heat of the moment. Instead, they derive from a failure of approach, specifically a failure to follow the very manual that they had drafted or participated in drafting almost 18 months previously. Dr. Kristensen's evidence. In light of these findings, I come to Dr. Kristensen. It was ultimately accepted on the part of the plaintiff that it was not in itself sufficient to merely show a flood engineer could have or might have undertaken flood operations in accordance with one of Dr. Kristensen's simulations. Instead, it had to be shown that they would or must have done so. I have approached the simulations in that manner and in accordance with the analysis of the appropriate standard of care relevant to a reasonably competent flood engineer. However, the analysis of his evidence was undertaken in a context where the defendants did not seek to put forward some alternative methodology that was said to involve the use of rainfall forecasts and conform to the plaintiff's interpretation of the manual. The defendants drew a battle line at the point of bitterly opposing the use of rainfall forecasts in flood operations in any manner other than the limited use made of them by the flood engineers. They lost that battle. In Chapter 8, I address and reject the attacks on Dr. Kristensen's honesty and impartiality. I accept that he is sufficiently qualified to express the opinions he did, although his lack of experience in real-time flood operations and lack of detailed knowledge of Australian forecast products have affected my preparedness to accept particular aspects of his methodology. I do not accept that he consciously constructed his methodology and simulations with the benefit of hindsight. Although I commenced my consideration of his evidence with a strong scepticism that his hindsight knowledge of how the January 2011 event transpired may have subconsciously affected his evidence, that scepticism slowly dissipated as Dr. Kristensen responded to a skilled forensic grilling over weeks in the witness box. I'm satisfied the approach he outlined in most respects flowed from his interpretation of the manual's requirements, interpretation I largely accept. In contrast to many of the defendant's witnesses, Dr. Kristensen addressed what the manual actually states. He did not seek to make the express words of the manual conform to his preconceptions of how dam operations should have been conducted. Dr. Kristensen outlined a proposed methodology for flood operations, which broadly involved conserving flood storage when catchment conditions and forecasts indicated that there was a risk that the storage volume may be insufficient to contain predicted inflows, and then using the storage to reduce the magnitude or peak of the release of water from the dams, thus ensuring the timing of the peak release did not coincide with high downstream flows. In essence, Dr. Kristensen's approach involved 4 steps. His first step was to select a strategy in the manual based on modelling inflow volumes from the 8-day weather forecast for above the dams and predicting the likely storage level on the assumption that no releases are made. His second step was to make an assessment of whether reservoir storage should be created, that is, make releases greater than inflows, or filled, that is, allow inflows to exceed releases. If it was decided to increase storage, his third step was to select a release rate. In some of his simulations, this was undertaken by selecting a target level to lower the reservoirs to. Using the 4-day forecast, Dr. Kristensen predicted an inflow volume and then determined the period over which that amount would be released. The determination of that period, and hence the release rate, had regard to a number of factors including downstream conditions, the effect of shorter and longer term forecasts, reservoir levels, and the extent to which releases might take the dams below their respective full supply levels. In relation to the latter factor, in his primary simulations, Dr. Kristensen used the 4-day inflow estimate as the outer limit to which the dams could be taken below full supply level. The fourth step in Dr. Kristensen's proposed methodology was to regularly reconsider his approach, especially in light of changing conditions, including the publication of updated rainfall forecasts. As noted in the end result, Dr. Kristensen put forward 10 simulated counterfactual flood operations for the January 2011 flood event. The simulations had different start dates and governing assumptions. Some of those assumptions were at variance from Dr. Kristensen's primary methodology as just outlined. Consistent with what I've just stated, the defendants' attacks on this methodology were ferocious and detailed. They are addressed in Chapter 9 and Chapter 10. What follows here is a brief précis of the findings concerning his simulations and those criticisms. While I accept that Dr. Kristensen's overall methodology was consistent with the manual, in the end result I'm not persuaded that 4 particular aspects of his approach represent aspects of flood operations that a reasonably competent flood operations engineer would have adopted. First, I'm not persuaded that a reasonably competent flood engineer was required to use an 8-day forecast for the purpose of predicting reservoir levels under the manual to select strategy. The manual refers to the use of best forecast rainfall and streamflow information for the purpose of determining the maximum storage levels in the dams and determining peak flow rates downstream. The evidence suggests that the most accurate forecast was the 1-day quantitative precipitation forecast, or QPF, issued by the Bureau of Meteorology. While this was the best forecast product available for assessing downstream flow rates, it was not the best for predicting upstream dam inflows, because the size and consideration of the upstream catchments meant that 24 hours represents too short a planning period for determining strategy and making release decisions. That said, the evidence concerning the reliability of the 8-day forecast was such that I consider that it would be open to a reasonably competent flood engineer to reject its use in determining strategies and releases under the manual. Nevertheless, the evidence concerning the reliability of the 4-day forecast, combined with the necessity to make assessments for periods longer than 24 hours, meant that it represented the forecast product that a reasonably competent flood engineer was obliged to use for this purpose, provided that the approach to modelling and releases addressed its uncertainties, which Dr. Kristensen does. Beyond this, there was a debate about the manner of identifying the depth and location of rainfall from the 4-day forecast, and then the approach to modelling a predicted inflow volume from that forecast. In the end result, I'm satisfied that any legitimate debate about those matters is not material to my acceptance of 3 of Dr. Kristensen's simulations. Second, so far as making releases below full supply level are concerned, I am not persuaded that a reasonably competent flood engineer would or must have adopted an approach of being prepared to make releases below full supply level to the depth where they could be refilled by an estimate of inflows based on the 4-day forecast. However, I am satisfied that at least in the circumstances prevailing in January 2011, a reasonably competent flood engineer would have conducted flood operations on the basis of releasing below full supply level to an amount that was no more than the volume represented by the 1-day forecast, the QPF, if it was otherwise necessary to meet the manual's objectives. In January 2011, the 4- and 8-day forecasts were pointing to a much larger rainfall than the QPF, and that was at a time that was only part-way through a rainfall season influenced by a La Nina event. A flood engineer who released to below full supply level by an amount that was no more than the predicted inflow from the QPF forecast would have had a very high level of satisfaction, to the point of almost certainty that at the conclusion of the flood event, or shortly afterwards, each dam would be at its respective full supply level. Third, the defendants criticised many aspects of the approach of Dr. Kristensen's simulations on 11 January 2011, when reservoir levels would have approached, and in some simulations exceeded, elevation levels 74 metres. I reject the defendants' criticisms of his approach, save that in respect of those simulations in which the simulated reservoir level would have exceeded elevation levels 74 metres, I accept that a reasonably competent flood engineer could have adopted certain alternative gate openings suggested by an expert called on behalf of Sunwater, Mr. Andrew Eichart. Fourth, 2 of Dr. Kristensen's simulations assume that the crest gates at Somerset Dam could be opened and closed during flood operations. Given the uncertainty associated with the failure level of Somerset Dam if the crest gates are closed, I do not accept that a reasonably competent flood engineer would have adopted that assumption. Otherwise, I note that a considerable amount of evidence was adduced concerning the practices at other dams in Australia and overseas. This was undertaken with the general objective of establishing that Dr. Kristensen's approach, especially his use of forecasts, was a departure from a supposed usual or proper practice of only conducting flood operations based on writing on the ground modelling, and was thus unreasonable. It was also adduced with the specific objective of supporting the invocation of Section 22 of the Civil Liability Act of Queensland. It failed at both levels. No such practice was established in relation to Australian dams. More significantly, what the evidence revealed is that whether or not rainfall forecasts are to be used in flood operations is a decision that is usually recorded in the relevant water control manual, and not a decision made by the flood engineers conducting flood operations. Whether they are so used and recorded is usually a product of an analysis of conditions specific to the particular dam, including its location, purpose, priorities, timing of upstream flows, timing of downstream flows, catchment characteristics, dam capacity, forecast capacity, and the stability of the seasonal weather. In this case, the position of the manual on the topic of rainfall forecast was very clear. The findings that were made about the operation of the crest gates at Somerset Dam invalidated 2 of Dr. Kristensen's simulations, namely simulation I and J. The findings made about the use of the 8-day forecast, the use of the 4-day forecast as a limit on releases below full supply level, a residual concern about the use of Dr. Kristensen's target method, as well as concerns over the sensitivities of the calculation of info volumes based on 4-day forecasts, were such as to leave me unsatisfied that a reasonably competent flood engineer would have conducted flood operations in accordance with Dr. Kristensen's Simulation A and Simulation E. Simulation C was modelled to commence on 2 January 2011. Unlike Dr. Kristensen's primary methodology, Simulation C used 1-day forecasts as a basis for selecting strategies and making releases. In light of the findings about the use of 4-day forecasts, that assumption represented a conservative one from the plaintiff's perspective. Simulation C also used the one-day forecast as the outer limit at which it would seek to make releases below full supply level. Although there was a debate about whether arithmetical errors in the calculation of inflow volumes based on one-day forecasts affected the validity of the simulation, that dispute falls away in light of the finding about the utilisation of the 4-day forecast. Both simulations F and H were modelled to commence at midnight on 8 January 2011. Simulation F utilised 8-day forecasts to select strategies, whereas Simulation H used one-day forecasts in a manner similar to Simulation C. Nevertheless, both simulations were relevantly identical. This is so because on the evening of 7 January 2011, all forecasts of whatever duration require the adoption of at least strategy W3 and the making of maximum possible releases up to the point that the downstream threshold for non-damaging flows, namely 4,000 cubic metres per second at Mogul, was not exceeded. It follows that the findings about the utilisation of 4-day forecasts supports both simulations F and H. With simulations C, F and H, many of the defendants' objections to Dr. Kristensen's primary methodology and modelling either did not arise, or if they did, upon closer analysis, they were either not established or not sufficiently material to invalidate them. Any scope for legitimate disagreement is the interpretation of a particular forecast, the appropriate continuing loss rates, the estimation of inflow volumes, concerns over the capacity of Ivanhoe Dam to refill to full supply level, and the use of the target approach or some other quantitative use of 4-day forecasts to set releases were immaterial to their acceptance. Accordingly, for the reasons set out in the balance of the judgment, I am satisfied that a reasonably competent flood engineer who inherited the circumstances prevailing as at midnight on 2 January 2011 would have at a minimum made flood releases substantially in accordance with Simulation C up to and including 9 January 2011 and made flood releases substantially in accordance with the simulation thereafter. Similarly, I'm satisfied that a reasonably competent flood engineer who inherited the circumstances prevailing as at midnight on 8 January 2011 would have made releases substantially in accordance with Simulation F and Simulation H, as varied by Table 18 to Mr Eichhardt's response report dated 30 November 2017. Of these simulations, Simulation C represents the most favourable to the plaintiff, and it is the appropriate counterfactual for causation purposes. Duty of care and breach. I accept that Seckwater and each of the flood engineers owed a duty of care in the terms alleged by the plaintiff. The exercise of control over releases at Ivanhoe Dam conferred a significant level of control over flows in the Brisbane River downstream of the dams, although the precise level of that control differed on whether the relevant river location was upstream or downstream of the confluence of the Brisbane River and Lockyer Creek and the confluence of the Brisbane River and the Bremer River. This level of control corresponded to a significant but not complete level of control over the risk of flooding from the Brisbane River breaking its banks. Persons who had an interest in real and personal property, which by reason of its location downstream and its elevation was susceptible to flooding from the Brisbane River breaking its banks or flooding in the lower part of Lockyer Creek and the Bremer River, were correspondingly vulnerable to any negligent exercise of the power of control over dam outflows exercised by Seckwater and the flood engineers. Although the class of persons to whom such a duty was owed was very large, that did not render it indeterminate in the sense used in the authorities. The matters raised by the defendants that were said to be inconsistent with the existence of such a duty did not negate its existence. I also accept that Sunwater owed a duty of care, but it was only owed in respect of the provision of, quote, flood management services, end quote, pursuant to its agreement with Seckwater. I do not accept that either Seckwater or Sunwater owed a non-delegable duty of care. Otherwise, I accept that each of Seckwater, Sunwater and the state are vicariously liable for any breaches of the duty of care owed by the flood engineers that they each employed. The standard of care owed by the flood engineers was that of the reasonably competent flood engineer. In the end result, no issue under Section 36 of the Civil Liability Act of Queensland arises, because the liability of each defendant is a true vicarious liability, that is, a liability arising from a breach by a flood engineer in respect of a duty of care owed by a flood engineer. None of the flood engineers are public or other authorities for the purposes of Section 36. Thus, no question arises as to the wrongfulness of the exercise or the failure to exercise a function of a public or other authority before each flood engineer's liability is attributed to the defendants. In any event, in relation to each of the defendants, it was not established that this was a proceeding that is based on an alleged wrongful exercise of or failure to exercise a function of a public or other authority. Section 22 of the Civil Liability Act of Queensland is potentially engaged in respect of the breaches alleged against the flood engineers, but all the attempts to invoke it fail as a matter of fact. The plaintiff's case in Nuisance fails, as it was not demonstrated there was an unreasonable interference with its use and enjoyment of its interest in land. The claim in Trespass also fails. In relation to negligence, the allegations of breach of duty addressed in Chapter 12. I do not accept the plaintiff's case on breach is tied to establishing that on each and every day of the January 2011 flood event, the relevant flood engineers failed to act in accordance with one or more of Dr. Kristensen's simulations. Instead, the allegations of breach are addressed in a manner consistent with the findings concerning the manual, and so much of Dr. Kristensen's simulations and methodology that I have accepted were required of a reasonably competent flood engineer, that also being reflected in the absence of simulations C, F and H. In that regard, I'm satisfied that Mr. Malone committed breaches of duty during the period he was duty flood operations engineer from 2 to 6 January 2011, that thereafter each of the flood engineers committed breaches of duty while they were on shift during the period from 6 to 10 January 2011, and that Mr. Eyre committed a breach of duty when he was not on duty but still supervising flood operations as the senior flood operations engineer. Causation. Beyond the acceptance of Simulation C as the relevant counterfactual flood operation, two significant issues were litigated in relation to causation. The first was the utility of Dr. Altanacker's modelling for the purpose of determining, on the balance of probabilities, what the level of inundation would have been had outflows from Ivanhoe Dam accorded with Dr. Kristensen's simulations, including Simulation C. The second was whether causation in respect of all greater flooding occasioned by the flood engineer's breaches of duty could be established in respect of a particular flood engineer, specifically Mr. Ruffini, who was only on duty for a limited period during the January 2011 flood event. In relation to the first issue, although there were criticisms of Dr. Altanacker's modelling, the only expert evidence that was adduced in response to it raised only a few limited objections to his modelling. They are addressed in Chapter 13 along with the balance of the defendant's criticisms. Otherwise, that expert, Mr. Neil Collins, described Dr. Altanacker's modelling as, quote, pretty impressive, end quote, although he also asserted there was a superior hydraulic model available that was commissioned as a result of the Brisbane River Catchment Flood Study. That other model was not tendered, such that the assertion as to its superiority is only that. However, the concession that Dr. Altanacker's modelling was, quote, pretty impressive, end quote, remained. Overall, I'm satisfied that Dr. Altanacker's modelling is sufficiently reliable that when considered with the other evidence, it supports findings on the balance of probabilities as to whether or not the plaintiff's store would have been inundated by floodwater if the flood engineers had conducted flood operations substantially in accordance with Simulation C. Leaving aside Ms. Harrison, the same applies in relation to Dr. Altanacker's modelling of the inundation of the homes of the other sample group members, although it is not possible at this stage to address every aspect of the causation component of their cases. That must await the identification of the particular harm they each seek to recover damages in respect of. However, Dr. Altanacker's modelling is not to be treated as determinative of the precise level of flooding under Simulation C at every downstream location. There were some aspects of uncertainty demonstrated with his modelling. Specifically, it simulated flood levels within 2 kilometres of an inflow discharge and a discrepancy of up to 200 cubic metres per second at the peak of a boundary inflow discharge utilised by the modelling on the Bremer River just past its confluence with Worrell Creek. Instead, Dr. Altanacker's modelling must be considered together with all the other evidence concerning flooding at a particular location. The framework for that assessment, should it be necessary to undertake, is set out in Chapter 13. In relation to the second issue concerning causation, I'm satisfied that each of the flood engineers' breaches of duty, including those of Mr. Ruffini, were necessary to complete a set of conditions that were jointly sufficient to account for the occurrence of the particular harm at the plaintiff's store and such other forms of particular harm at or to group members' property that is proven to be the result of the difference in outflows between the events that happened and simulation C. This is sufficient to satisfy section 11(1)(a) of the Civil Liability of Queensland in respect of each flood engineer's breaches of duty. Subsection 11(1)(b) is also satisfied. In relation to the property of the plaintiff and the sample group members, I am satisfied on the balance of probabilities that, first, in respect of all relevant loss and damage proven to have been suffered by the plaintiff from the inundation of its store and the shopping centre that it formed part of, duty, breach and causation have been established against each of the defendants. Second, in respect of such loss and damage that was occasioned to Mr and Mrs Keller, Ms Visser and Ms Lynch from the inundation of their homes and Ms Lynch's shed and cottage, duty, breach and causation have been established against each of the defendants. Third, it has not been established on the balance of probabilities that but for the defendant's breaches of duty, the flooding would not have reached above the ground level of the storage facility at which Ms Harrison's shipping container was stored. For the reasons set out in Chapter 13, should it be necessary, the balance of the causation issues in respect of the sample group members should be litigated together with all quantum issues concerning them. Quantum and cross-claim. A number of issues concerning the quantum of the plaintiff's claim were litigated, all of them addressed in Chapter 14. Two of the issues were said to have implications for group members. The first was the effect on the plaintiff's claim for damages of certain grants received from the Queensland Rural Adjustment Authority under the Special Disaster Assistance November 2010 to January 2011 scheme. As discussed in Chapter 14, those grants were paid under a statutory scheme that effectively conferred an entitlement on small businesses to be reimbursed for particular costs incurred as a result of flood damage during the January 2011 flood event. To the extent that the plaintiff and other group members seek recovery of a cost item or invoice in respect of which they received a grant, then their damages will be reduced accordingly. I am satisfied that the legislature did not intend that a flood victim recover twice in respect of the same invoice or cost item. The second issue was whether the plaintiff can recover the commercial cost of the time spent by Mr Rodriguez and various volunteers known as the Mud Army in cleaning up its store and cleaning and repairing stock. For the reasons given in Chapter 14, the answer is yes. Each of the defendants filed cross-claims against each other. The plaintiff has only been successful in negligence, and that part of its claim is an apportionable claim within the meaning of Section 28 of the Civil Liability Act of Queensland. It follows from that conclusion that all of the cross-claims for contribution fail. Seqwater's cross-claim against Sunwater also included a claim for damages for breach of the agreement between them. The damages claimed are for any liability that Seqwater incurs in favour of the plaintiff and group members, as well as its costs of defending the proceedings. These forms of damage are all forms of consequential loss, which Seqwater is contractually excluded from recovering from Sunwater. Accordingly, Seqwater's cross-claim against Sunwater fails. Further conduct from the proceedings. It follows from these proceedings that the plaintiff succeeds in its negligence claim against all of the defendants, as will presumably many but not all of the group members. After I pronounce answers to the common questions, I'll make order standing the proceedings over to February 2020 to allow the parties to consider the judgment and plan the next steps in the litigation. Question 1. In the period 2 January 2011 to 11 January 2011, A, was Seqwater, Sunwater, and alternatively their employees and agents prohibited by law from releasing water from Somerset Dam or Wivenhoe Dam below the full supply level for each dam for the purposes of conducting flood operations? Answer, no. B, if the answer to A is no, in what circumstances could such releases be made? Answer, where the exercise of reasonable care in the conduct of flood operations warranted it. Question 2. Were the risks of harm associated with the failure to conduct flood operations with reasonable care at Somerset Dam and Wivenhoe Dam those pleaded in paragraph 142 A of the 5th amended statement of claim? Answer, save for the reference to, quote, a failure properly to conduct flood operations at Somerset Dam and Wivenhoe Dam, end quote, paragraph 142A of the 5th further amended statement of claim is an appropriate formulation of the risk of harm. Question 3. Any of Seqwater, Sunwater, or any of the flood operations engineers owe a duty or duties of care to a class comprising the plaintiff and the group members to exercise reasonable care in the conduct of flood operations at Somerset Dam and Wivenhoe Dam so as to avoid or minimise the risk of harm. Answer. Each of Seqwater and the flood operations engineers owed such a duty care to a class that included the plaintiff and group members. Sunwater owed such a duty to a class that included the plaintiff and group members, but only in respect of the supply of flood management services under the, quote, service level agreement flood management services, end quote, dated 30 October 2009. Question 4. Does the answer to question 3 differ depending, A, on whether the risk of harm was a risk of physical damage to real property? Answer, no. B, on whether the risk of harm was a risk of physical damage to personal property? Answer, no. C, on whether the risk of harm was a risk of physical damage to real or personal property located near the Brisbane River between Wivenhoe Dam and Moggill? Answer, no. D, on whether the risk of harm was a risk of physical damage to real or personal property located near the Brisbane River between Moggill and the mouth of the river? Answer, no. E, on whether the risk of harm was a risk of physical damage to real or personal property located near the Bremer River? Answer, no. F, on whether the risk of harm was a risk of physical damage to real or personal property located near Lockyer Creek? Answer, no. Question 5. If the answer to question 3 is yes, what was the applicable standard of care for A, Seqwater, B, Sunwater, and C, each of the flood engineers? Answer, in respect of Seqwater and Sunwater, unnecessary to answer. In respect of the flood engineers, the standard of care is that of the reasonably competent flood engineer. Question 6. Did Seqwater breach any duty of care that it is found to have owed in the manner pleaded? Answer, on the assumption that this question is directed to a breach of a non-delegable duty, does not arise. Question 7. Did Sunwater breach any duty of care that it is found to have owed in the manner pleaded? Answer, on the assumption that this question is directed to a breach of a non-delegable duty, does not arise. Question 8. Did Mr Malone and or Mr Tiboldi breach any duty of care that they are found to have owed in the manner pleaded? Answer, yes, both of them in some respects. Question 9. Did Mr Eyre breach in the manner pleaded any duty of care that he is found to have owed? Answer, yes, in some respects. Question 10. Did Mr Ruffini breach any duty of care that he is found to have owed in the manner pleaded? Answer, yes, in some respects. Question 11. In carrying out flood operations in the period 2 January 2011 to 11 January 2011, did Seqwater, Sunwater and the flood engineers act in a way that was so unreasonable that no authority having the functional power in question could properly consider the act or omissions to be a reasonable exercise of the function of power within the meaning of Section 36 of the Civil Liability Act of Queensland or Section 43A of the Civil Liability Act of New South Wales? Answer, this question does not arise. Question 12. In carrying out flood operations in the period, did Seqwater, Sunwater and each of the flood engineers act in a way that was widely accepted by peer professional opinion by a significant number of respected practitioners in the field as competent professional practice within the meaning of Section 22 of the Civil Liability Act of Queensland or Section 5.0 of the Civil Liability Act of New South Wales? Answer, in respect of Seqwater and Sunwater, the question does not arise. In respect of the flood engineers, no. Question 13. In the circumstances, would a reasonable person in the position of the flood engineers have operated the dam substantially in accordance with any of the simulations A to G of the response report? Answer, a reasonably competent flood engineer in the position of the flood engineers who inherited the circumstances prevailing as at midnight on 2 January 2011 would have, at a minimum, made flood releases substantially in accordance with Dr. Kristensen's simulation C up to and including 9 January 2011 and made flood releases substantially in accordance with that simulation thereafter. A reasonably competent flood engineer in the position of the flood engineers who inherited the circumstances prevailing as at midnight on 8 January 2011 would have made flood releases for the balance of the January 2011 flood event substantially in accordance with Dr. Kristensen's simulation F as varied by Table 18 to Mr. Eichhardt's response report dated 30 November 2017. Question 14. In failing to operate the dam substantially in accordance with any of simulations A to J in Dr. Kristensen's response report, A, did Seqwater Sunwater or any of the flood engineers breach any pleaded duty of care? B, did Seqwater Sunwater or any of the flood engineers act in a way that was so unreasonable that no authority having the functional power in question could properly consider the acts or omissions to be a reasonable exercise of the functional power within the meaning of Section 36 of the Civil Liability Act of Queensland or Section 43A of the Civil Liability Act of New South Wales? And C, did Seqwater Sunwater or any of the flood engineers act in a way that was widely accepted by peer professional opinion by a significant number of respected practitioners in the field as competent professional practice within the meaning of Section 22 of the Civil Liability Act of Queensland or Section 50 Civil Liability Act of New South Wales? Answer: these questions did not arise. Question 15. If Mr Malone and Mr Tibaldi or one of them breached their duty of care, is Seqwater vicariously liable for the breach? Answer: yes. Question 16. If Mr Eyre breached his duty of care, is Sunwater vicariously liable for the breach? Answer: yes. Question 17. If Mr Raffini breached his duty of care, is Sunwater or the state vicariously liable for the breach? Answer: the state and not Sunwater. Question 18. Did any breach of duty of care that is found to have occurred cause flooding or greater flooding downstream of Wivenhoe Dam than would have occurred otherwise? Answer: the breaches of duty of each flood engineer caused greater flooding downstream of Wivenhoe Dam than would have occurred otherwise. Question 19. Was the measure of that flooding or greater flooding that determined by the modelling of Dr Mustafa Altanaka? Answer: Dr Altanaka's modelling is not the determinative measure of that flooding or greater flooding. Question 20. Does the modelling of Dr Altanaka determine what the level of flooding would have been at locations downstream of Wivenhoe Dam if Wivenhoe and Somerset dams had been operated substantially in accordance with simulations A to J in Dr Kristensen's response report? Answer: Dr Altanaka's modelling is not determinative of that level of flooding. Question 21. Did the release of water from Wivenhoe Dam onto land in which the subgroup members held an interest in the period 9 January 2011 to 19 January constitute a private nuisance by Seqwater, Sunwater and or alternatively any of the flood engineers? Answer: no. Did the release of water from Wivenhoe Dam onto land in which the subgroup held an interest in the period 9 to 19 January 2011 constitute a trespass by Seqwater, Sunwater or alternatively any of the flood engineers? Answer: no. Question 23. Did the fences of statutory authority and necessity provide a defence to private nuisance and trespass? Answer: not in this case. Question 24. If Mr Malone and Mr Tibaldi or one of them committed the private nuisance or trespass, is Seqwater vicariously liable for that private nuisance or trespass? Answer: does not arise. Question 25. If Mr Eyre committed the private nuisance or trespass, is Sunwater vicariously liable for that private nuisance or trespass? Answer: does not arise. Question 26. If Mr Raffini committed the private nuisance or trespass, is Sunwater or the state vicariously liable for that private nuisance or trespass? Answer: does not arise. Question 27. Is the state liable, and if so, to what extent, by operation of Section 374 of the Water Supply Safety and Reliability Act of Queensland? Answer: no. Question 28. If damages are recoverable against any of the defendants, are any of the claims apportionable claims within the meaning of Section 28 of the Civil Liability Act of Queensland or alternatively Section 34 of the Civil Liability Act of New South Wales? Answer: the plaintiff's claim in negligence is an apportionable claim within the meaning of both Section 28 of the Civil Liability Act of Queensland and Section 34 of the Civil Liability Act of New South Wales, depending on which is applicable. Otherwise, unnecessary to answer. Question 29. If yes to question 28, what is the appropriate amount of any judgment against any defendant in regard to Section 31 of the Civil Liability Act of Queensland or alternatively Section 31 of the Civil Liability Act of New South Wales? Answer: not appropriate to answer at this point. Question 30. What are the respective rights and liabilities as between the defendants in the event that one or more of them is liable to the plaintiff or one or more group members? Answer: not appropriate to answer at this point. Question 31. Should money received by the plaintiff and group members from the Queensland Rural Adjustment Authority as the Queensland Government's administrator of schemes of governmental support established by the Rural and Regional Adjustment Act of 1994 Queensland be taken into account in the assessment of any damages, and if so, in what way? Answer. In respect of the plaintiff, 1. To the extent that the plaintiff's claim for damages includes the cost of replacing and repairing store equipment, then an amount of up to $4,598.95 should be deducted from his damages, but not otherwise, and such deduction is to occur before any apportionment of the amount of damages to be paid by each defendant to the plaintiff. 2. To the extent that the plaintiff's claim for damages includes the cost of replacing or repairing store equipment, then an amount of up to $2,937.93 should be deducted from its damages, but not otherwise, and such deduction is to occur before any apportionment of the amount of damages to be paid by each defendant to the plaintiff. And 3. To the extent that the plaintiff's claim for damages includes the cost of replacing lost or damaged stock, then an amount of up to $17,463.22 should be deducted from its damages, but not otherwise, and such deduction is to occur before any apportionment of the amount of damages to be paid by each defendant to the plaintiff. In respect of group members who receive grants from the Queensland Rural Adjustment Authority under the scheme created by Part 29 of the Rural and Regional Adjustment Regulation 2000, for no more than $5,000, then to the extent they can otherwise recover in the proceedings costs of the kind referred to in subclause 288, subclause 2 of the regulation, the grant should be deducted from their damages but not otherwise, and such deduction is to occur before any apportionment of the amount of damages to be paid by each defendant to that group member. In respect of group members who receive grants from the Queensland Rural Adjustment Authority under the scheme created by Part 29 of the regulation of more than $5,000, then to the extent they can otherwise recover in these proceedings the costs of the material, the cost the subject of the material provided to comply with clause 291 of the regulation, then the grant should be deducted from their damages, but not otherwise, and such deduction is to occur before any apportionment of the amount of damages to be paid by each defendant to that group member. In respect of group members who receive grants under the Rural and Regional Adjustment Act, but not under the scheme created by Part 29 of the regulation, are necessary to answer. Question 32. Are the plaintiff and group members entitled to damages for their own labour and or the labour of volunteers in carrying out rectification and repairs? Answer. In respect of the plaintiff, yes. In respect of the group members, and assuming that the question relates to rectifications and repairs to real or personal property that is owned or leased by them, yes. Otherwise, unnecessary to answer. Question 33. If yes, is the entitlement to damages based on the reasonable commercial cost of those services or some other measure? Answer. The quantification of the loss is based on the reasonable commercial cost of those services. Question 34. Does the commencement or maintenance of these proceedings mean that group members have brought an action founded on tort within 6 years from the date on which their cause of action arose within the meaning of Section 10(1)A of the Limitation of Actions Act of Queensland? Answer, yes. Question 35. If the answer to 34 is no, in respect of any or all group members to Section 182 of the Civil Procedure Act 2005, or any equivalent provision, operate to suspend the limitation period applicable to group members' claims in these proceedings? Answer, does not arise. Question 36. For the purpose of formulating a judgment conforming to Section 179A of the Civil Procedure Act, which answers to each question above, alternatively, which findings made for the purposes of answering each or any questions above, bind A, the plaintiff, B, any and if so which sample group members, C, any and if so which group members, D, all group members? Answer. The plaintiff, the sample group members and the defendants are bound by the above answers and all the findings in this judgment. In respect of the remaining group members, not necessary to answer at this stage. Lastly, lists these orders. The orders the court makes are: 1. Proceedings stand over to 9:30am on 21 February 2020 for directions. 2. By no later than 7 February 2020, the parties are to confer as the further progress of the proceedings. I publish my reasons. Court will adjourn.
Silence.
It's helpful.
Thank you, mate.